Welcome to another episode on the Law Report. This is episode 53. Today, we are going to deal with intent or intention in criminal cases. But before I do, my usual disclaimer, this is not legal advice, should not be construed as legal advice. For legal advice, please contact an attorney of your choice. Intention in criminal law is the mens rea or the state of mind of a defendant when he allegedly commits a crime or an offense. Most crimes will require proof of that mens rea. Where mens rea is not required for an offense, the offense is one of strict liability, and I will deal with that in another episode. There are three main levels of mens rea. There are the intention, there's recklessness, and there's negligence. Today's episode will focus on intention. Many of you would have heard a person being charged with a serious offense. An offense where it is alleged that he intended to do something, probably assaulting someone with intention to commit grievous bodily harm, entering someone's property as a trespasser with intent to commit theft, or taking the life of another with malice aforethought. Malice aforethought is simply intention. Intention requires the highest degree of fault at all levels of the state of mind. A person who intends to commit a crime can generally be said to be more culpable than one who acts recklessly. Intention is different than a motive or a desire. This was established and discussed in the case of Regina and Maloney of 1985, where Lord Bridge states, a person who kills a loved one dying from terminal illness in order to relieve pain and suffering may well act out of good motives. Nevertheless, this does not prevent them from having the necessary intention to kill. This was further explained in the case of Regina and Inglis in 2011. Now, intention can be divided into two. One is direct intent and the other is oblique intent. Direct intent in a majority of cases will be straightforward and the involvement may be direct. Direct intent can be said to exist where a defendant embarks on a course of conduct to bring about a result in which his intent occurs. For example, a man intends to kill his wife. To achieve this result, he gets a gun from a friend. He takes lessons in the use of a firearm. Then he shoots her in the head, killing her. The conduct achieves the desired result. Oblique intention, on the other hand, is more complex. It can be said to exist where a defendant embarks on a course of conduct to bring about a desired result, knowing that the consequences of his actions will also bring about another result. For example, a man intends to kill his daughter's boyfriend. He goes to his daughter's apartment and poisons a 6-pack of beer, hoping that the boyfriend alone will consume them. However, unbeknown to him, probably, the daughter also consumes alcohol. Or he knows that the daughter consumes alcohol, but he believes the boyfriend alone will drink or consume the 6-pack of beer. So later, the boyfriend and his daughter consume the beers and both die from poison. The father knows that his action will result in death of anyone drinking the beers, but he did not expect his daughter to partake, even though it may not have been part of his desire for his daughter to consume the beers. He is no less culpable in killing her, as he knew that death will happen as a result of his actions. The court, over the years, have struggled to find an appropriate test to apply in cases of oblique intent. In particular, the question which have vexed the court are: should the test be subjective or objective? What degree of probability is required before it can be said that the defendant intended the result? Whether the degree of probability should be equal to intention, or whether it is evidence of intention from which a jury may infer intention. The subjective or objective test. The subjective test is concerned with the defendant perspective. In relation to oblique intention, it will be concerned only with whether the defendant did foresee the degree of probability of the result occurring from his actions. The objective test looks at the perspective of a reasonable person. That is, would a reasonable person have foreseen the degree of probability as a result occurring from the defendant's actions? It is arguable that since intention requires the highest degree of fault, it should be solely concerned with the defendant's perception. In addition, intention seems to be a concept which naturally requires a subjective inquiry. It seems somehow wrong, in my view, that the defendant's intention should be a reference to what a reasonable person would have contemplated. However, originally an objective test was applied to determine oblique intent, as in the case of the Director of Public Prosecutions and Smith in 1961. This position was reversed by statute in the United Kingdom by virtue of Section 8 of the Criminal Justice Act of 1967. But it may still be the common law position and therefore applies in the Turks and Caicos Islands, since we are primarily a common law jurisdiction and there has been no statute and intention in the Turks and Caicos Islands. Section 8 of the Criminal Justice Act deals with proof of intent, and it states that a jury or court in determining a person has committed an offense shall not be bound in law to infer that he intended or foresee a result of his actions by reason only of it being a natural and probable consequence of those actions, but shall decide whether he did intend or foresee that result by reference to all the evidence, drawing such inferences from the evidence as appear proper in the circumstances. And Section 8 was considered in the case of Hyam of 1975. In this case, the court did accept that the subjective test was applicable. However, the majority decision of the House of Lords, as it was then, it's now the Supreme Court, was out of line with Section 8 in that it was accepted that foresight of consequences being highly probable was sufficient to establish intent. In the case of Regina and Maloney of 1985, the situation was somewhat rectified, where Lord Bridge set out a test and oblique intention. And this was first question to be asked was if the death or serious injury in a murder case, for example, or whatever relevant consequence must be proved to have been intended in any other case, if that was a natural consequence of the defendant's voluntary act. The second question to be asked is, did the defendant foresee that consequence has been a natural consequence of his act? The jury should then be told that if the answer yes to both questions, it is proper to infer from them that the defendant intended the resulting consequence. However, it was felt by many that the case of Maloney left a problem with regard to the degree of probability required, and that this problem needed to be resolved. So in the case of Nedrick of 1986, this issue was addressed. And Lord Lane, Chief Justice at the time, pointed out that the jury should be directed that they are not entitled to infer the necessary intention unless they feel sure that death or serious bodily harm was a virtual certainty, barring some unforeseen intervention as a result of the defendant's actions, and that the defendant appreciated that such was the case. So In the United Kingdom, for example, in a case of murder, intent could be inferred if a jury feels sure that death or serious bodily harm was a virtual certainty. In the Turks and Caicos Islands, the way how our ordinance, offences against the person ordinance is worded, it is only if a jury feels sure that death was a virtual certainty that intent could be inferred. So while in the UK, it is either death or serious bodily harm, in the Turks and Caicos, it is only if a defendant foresee that death could have resulted from his actions that intent could be inferred. However, the authority of this test was questioned in the case of Regina and Woolen in 1999. So the current test for oblique intent, where the charge is one of murder, and in the rare case where a simple direction is not enough, the jury should be directed that they are not entitled to find the necessary intention unless they feel sure that death or serious bodily harm was a virtual certainty, barring some unforeseen intervention as a result of the defendant's actions, and that the defendant appreciated that such was the case. The decision is one for the jury to be reached upon a consideration of all the evidence. So in summary, intention usually occurs where a defendant desires the consequences of his actions. Indirect intent may be found where the defendant does not desire the consequences of his action, but those consequences are virtually certain and the defendant knows that they were virtually certain. Specific intent refers to offences where intention is necessary to satisfy the mens rea. Basic intent refers to offences where either intention or recklessness will satisfy the mens rea. Ulterior intent refers to offences where additional element is necessary to show that the defendant intended to do something in addition to the basic mens rea of the offense. Here is where I will leave this for today. I thank you for watching, and I will see you in another episode.